Hello everyone, welcome to the second class of this MOOC course on conflict management through mediation. Today we will be talking about need for ADR. My name is Tarishi Agrawal. I work as a research associate at Chair on Consumer Law and Practice, National Law School of India University, Bangalore. So, to begin with, I would be explaining the need of ADR with the help of some quotes. These quotes would be helpful in realizing the importance of ADR and why do we need an alternate dispute resolution mechanism. Because we have an existing mechanism to resolve our disputes, that is by going to the courts, that is the litigation process. So as against the litigation process, what is the need of ADR, why is it needed, that we would be seeing with the help of some quotes initially. So before you have a picture of two kings. These emperors are sitting across the table and they are playing chess and discussing. So this is a conversation wherein one king says to the other one that I'm glad we settled our conflict this way. War is expensive. So as you can see that these people, while they are sitting across the table, they can have a conversation and resolve their conflict and dispute there itself, rather than going on a war, which is a very expensive affair to have, and also it would lead to a mass destruction of time, money, resources, etc. Similarly, when we talk about this in the legal context, we can say that in a similar manner, even litigation is expensive and it is better to get your conflict resolved by way of an ADR, that is alternate dispute resolution mechanism. So, litigation in similar terms it requires a lot of time, it requires a lot of resources, and it even takes away the personal relationship that you have built over years between the parties who are the party to a dispute. Now before you have a picture of Mr. Abraham Lincoln. So, Mr. Abraham Lincoln once said, "Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time." Now, what he was trying to convey is that one should discourage litigation and persuade the neighbors to arrive at a compromise, because in litigation the person who we perceive to be the winner is actually a loser, because he loses his money, he loses his time, his resources, and even the relationship which the party would be having prior to the litigative process. Next we have a quote by Mr. Mahatma Gandhi, which was in his autobiography, The Story of My Experiments with Truth. In that book, he said that I had learnt the practice of law. I had learnt to find out the better side of human nature and to enter men's hearts. I realized that the true function of a lawyer was to unite the parties driven asunder. I lost nothing thereby, not even money, certainly not my soul. So, in this we can actually see that what is the real role, or what is the true function of a lawyer, is to unite the parties who are having a situation of dispute or a rift between them. So a lawyer does not lose anything, not even money and not even his soul, but his true function is to unite the parties. However, when we enter into a litigative process, the parties barely unite. There is a win-lose situation wherein one party wins and the other party loses. Now before you have a famous line said by Mr. Nani Palkiwala ji, He said that if I am, there's a grammatical error here, if I am asked to mention the greatest drawbacks of our administration of justice in India today, I would say it is delay. The law may or may not be an ass, but in India it is certainly a snail, and our cases proceed at a pace which would be regarded as unduly slow in a community of snails. Justice has to be blind, but I see no reason why it should also be lame. Here it just hobbles along, barely able to walk. So, looking upon this, we can say that what Nani Palkiwala ji was trying to say was that the drawback of our administration system is the delay in the justice. That delay arises from the long pendency in the courts. Further ahead, I'll be showing you the pendency ratio that is existential at the current time. So, to put it into better words, the main drawback for the administration system is the delay in the administration of justice. That is because of the huge pendency in the cases. Now he has also tried to compare it with the journey of snails, that it would be unduly slow even in the community of snails also. So the justice should not be delayed, because justice delayed is justice denied. Now you have a picture before you. That person is looking for there are different doors for resolution of his complaint. He has come for the resolution of his complaint, and there are different modes: mediation, negotiation, arbitration, and then there is a board for litigation, which will drag him down. So what we are trying to depict through this picture is that this person should rather opt for other methods of dispute resolution like arbitration, mediation, negotiation, conciliation, lok adalats, than go for litigation, which would drag him down, which would make him which would make him enter into a losing situation. How? By the loss of resources, time, money, hampering of relationships, whatnot. So it is always better to choose for ADR, alternate dispute resolution mechanisms, wherever it can be used, rather to go for the litigation process, which further delays the process of arriving at justice and takes you back, and the result that we come after the result that comes after litigation, that might also not be in that person's favor. But the try of an ADR procedure is to have a win-win situation for both the parties. Now I'll be stating some facts before you. So, the entrance of the Sanchi Stupa narrates the tale of the Battle of the Relics. Mythology states that the kingdom of Mallas held all of Buddha's relics and refused to part with any. This angered kings of 7 other countries, and war was imminent. Drona, a respected sage, intervened and questioned the motive behind the war. He reasoned that war will only lead to destruction and resentment among former allies in contravention to Buddha's ideology. Sense prevailed, and the kings agreed to the division of the relics. So, in this situation, as we can see, that there was a battle of the relics. So what had happened is that the kings of 7 other countries, they were angry because the kingdom of Mallas, they had held all the Buddha's relics and they were refused to give it away. So now this created an aggression for the other 7 countries, and everyone was anticipating a war. But Drona, this learned sage, he said that this would be contrary to Buddha's ideology itself, and war would only lead to destruction and resentment. So, listening to his words, these kings, they decided to for the division of the allies, for the division of the relics. Hence, the state of war was avoided. So, as we can see, rather than war, a simple conversation between a simple understanding between the kings and the understanding of the conflict situation could easily be resolved by way of talking and understanding each other's perspective rather than going for a war, which would lead again to destruction of resources. Now, when we talk about ADR, ADR also falls within the ambit of the Constitution. So, when we talk about Article 39A of the Constitution of India, it enjoins that the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall, in particular, provide free legal aid by suitable legislation or schemes to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. So when we look at Article 39A, it provides for legal aid. So when we talk about the legal aid, it can either be by way of courts. Now, going to court is an expensive affair. The parties have to hire a lawyer, because a lawyer is someone who is acquainted with the procedure. He is someone who specializes in the way of the operation of the court. So there he cannot what do we say? There he cannot fight merely on the basis of what he knows. He has to have specialized knowledge of the law. So, fulfilling the constitutional mandate, the ADR process is equally a very smooth and fruitful way of resolution of complaints complaints or disputes or conflicts between the people, thereby fulfilling the mandate of having a legal aid for every person. Plus, it is less expensive and it creates results which are even more fruitful than a litigation process. Now, when we talk about the importance of ADR, the alternate remedies provide cheap and speedy justice, and that is the reason that ADR mechanism is being preferred by disputing parties for the resolution of their dispute. Now, nowadays, the ADR phenomena, the alternate dispute resolution mechanisms, these have come in vogue lately because A, they are cheap, and B, they are speedy. Plus, ADR is an effective way of resolving the dispute, including other factors like it being cheap and speedy. So, parties prefer going for ADR mechanisms these days. Now, there was the Malamuth Committee report. This committee report underlined the need for ADR mechanisms as a viable alternative to conventional court litigation. So, the Malamuth Committee report was one of the reports which suggested the importance, which gave in the importance of the ADR process as opposed to the conventional court litigation process. Now, when we talk about disputes, broadly disputes can be classified into two parts, that is civil and criminal. Now, when we talk about civil disputes, they include disputes relating to contracts, property disputes, landlord-tenant disputes, personal injury claims, consumer disputes, debt recovery matters, and whatnot. The list goes on and on. These are some examples that we've given to you. So these are some civil disputes, and they can be easily resolved by alternate dispute resolution outside the court without following the formal procedure of court and going through the lengthy and tedious process. Whereas when we talk about the criminal disputes, so mediation in criminal cases is a precarious issue. It's again a grammatical error. It's is a precarious issue. Now, in very violent crimes which are very violent, in those type of matters, usually mediation is not used as a means to resolve the dispute. Now, when we talk about the different needs, why we need ADR, so these needs can be classified into 4 sections: the need of an individual, the need of the society, need of the state, and the need to comply with international obligations of providing speedy justice. So when we talk about the need of an individual, how is ADR useful for an individual? So first, it is quick. Resolution with the help of ADR is much more speedier than any other process. Courts take a lot of time. As I said, I'll show you the data of the court pendency cases. ADR is very quick. It is economical, not as expensive as the court process is. It is participative. The parties are equally involved. It is flexible, efficient, satisfactory. It creates a win-win situation for both the parties. The main aim of an ADR process is to allow both the parties to participate and create a win-win situation for both of them. Privacy and simple. So when we talk about ADR processes, ADR ensures that the privacy is not curtailed. For example, when we talk about mediation is itself a very confidential procedure, and the details are not let out. Next comes the need of the society. Harmony. So the society needs to have a harmonious situation to live in. There should be peace, there should be harmony. So that can be ensured by undertaking ADR. Cordial relations are maintained. The personal relationships that the party had even before coming into the litigation process. The ADR process ensures that the relations remain cordial. Peace is ensured. Cooperation is there between the parties. Fraternity and coexistence is promoted. As I said, the focus of ADR is to bring a win-win situation. So it tries to fraternize the parties and to ensure that they can coexist together. And certainty. Now, when we talk about the need of the state, it is to reduce the burden on the courts. Court already has a lot of pendency of cases, so it's best that we opt for other means of dispute resolution. That way we can reduce the burden on the courts as well. Then next comes the need to comply with the international obligation to provide speedy justice. We have an international obligation to provide speedy justice to the party. That obligation can be fulfilled by undertaking ADR as a mode to resolve complaints, because it is a lot more speedier and effective. Now, we can see before us the factors responsible for the need for ADR. So first in line we have population. So India's population reached 1,383 million people in March 2023, as compared with the previously reported figure of 1,368.6 million people in March 2022. So you can see that there is a huge leap in the population itself. So this increase in the population has resulted in an enormous increase in the number of litigation, because it is natural. If there are people existing in the society, there will be disputes. But if everyone resorts to courts, to the litigation process for the resolution of the complaints, there will be more and more complaints and cases which keep on piling up, and as a result the pendency ratio will increase. So the pendency, since it will increase, there will be a delay in the justice. That is why we can opt for ADR in the disputes that are suitable for it, and come up with an equally effective, or we can say even a much more effective way of resolution of complaints and cases. Next is docket explosion of cases. So as I was telling you that I'll be showing you a picture of the pendency of cases. So before you have the national judicial grid data grid. So as per the judicial grid, it says, you can see before yourself that the figure is enormous. The total number of disputes that are pending are enormous. It is right now in crores. So there is already a situation where there is a huge pendency, and with a growing population, that pendency would keep on increasing, since the number of cases in the court will keep on increasing if the people do not opt for other means of dispute resolution like ADR. When we talk about the hierarchy of judiciary in India, so you can see the chart before you. On the topmost level lies the Supreme Court, below that High Court, below that District Court and additional district judges, below that subordinate judge first class, subordinate judge second class, and then we have the Court of Small Cause for metropolitan cities, and Munsif's Court or courts of sub judges third class. So now the hierarchy we'll be discussing in brief in week 2 as well. So let me summarize it here for you. So that says that the Supreme Court has original, appellate and writ jurisdiction, apart from having advisory jurisdiction as well. The writ jurisdiction is under Article 32. The decisions of the Supreme Court are binding on all the courts. Next we have the High Court. They are responsible to hear the appeals from the lower court. They can issue writs to restore the fundamental rights as well as the legal rights under Article 226. It deals with the jurisdiction, it deals with cases within the jurisdiction of the state. Now when we talk about district court and additional district judges, they deal with the cases, civil or criminal, which arises in a district. They consider appeal on the decisions given by the lower courts, and they also decide on cases of severe criminal nature. Now when we talk about the courts that are below that, they consider cases of both civil and criminal nature. Now when we are discussing about the various factors, the third amongst them is the prolonged adjudication procedure. I'll tell you how this hierarchy is related here. So first is that when we go for adjudication, we have to identify an appropriate court. So in the slide before, we saw that we have a huge hierarchy. Which is the court? Which court has to be approached for the concerned matter has to be decided firstly. So it is talking about the determination of the court where the case has to be filed. The hierarchy of courts in India consists of the Supreme Court, High Court, subordinate courts. So accordingly, the decision has to be made that which court is the appropriate court to listen to that matter. Second is draft the complaint or petition. So, when we are talking about the court case, a written complaint or a petition which outlines the facts, the legal issues, the relief sought, that has to be highlighted. Then this document would serve as a formal presentation for the case. Next step would be to engage an advocate. The advocate is a person who would specialize in the court procedure, and he would take your case forward and present it before the court. Now the next step is the court fee payment. The payment of the court fees has to be done as has been prescribed under the Court Fee Act, which varies based on the nature of the case and the relief sought. This fees is usually determined on the basis of the value of the dispute. Next is a fixation of the court fees. Next comes the filing of the case. The next in line is case registration. Then summons or notice to the opposite party, filing of written statement by opposite party, hearing of witnesses, arguments by both the parties, judgment, appeal before higher courts. So when we talk about this, the reason why I'm not going in detail is because in week 2 I'll be explaining the entire adjudication process to you. So as you can see before yourself already, the whole process is quite long. Everything demands its own time. Plus, if in between there's an interim order that is passed, then again there can be an appeal or something. So the procedure keeps on going, and keeps on going. That is one major reason why we need to look at other alternatives now. Now, when we talk about tribunals, I can list out certain tribunals before you. First in line is the National Green Tribunal, that is the NGT. Now, the National Green Tribunal was established under the National Green Tribunal Act of 2010. Its jurisdiction is over the cases relating to environmental protection and conservation of forest and other natural resources. Next is the Income Tax Appellate Tribunal. This was established under the Income Tax Act of 1961, and the jurisdiction of the Income Tax Appellate Tribunal is over the appeals, that is against the orders of the Commissioner of Income Tax. Next is the Central Administrative Tribunal. This was established under the Administrative Tribunals Act of 1985. The jurisdiction is over disputes and complaints with respect to the recruitment and the conditions of service of persons appointed to public services and posts in connection with the affairs of the Union and other local authorities. Next, we have the National Company Law Tribunal, NCLT. So this was established under the Companies Act of 2013, and the jurisdiction is over corporate civil disputes arising under the Act. Multiple benches across India, each serving a specific geographical area. Special courts are also there in existence. One of them is the fast track courts. This, as the name suggests, fast track, which means that it was established to expedite the judicial process and clear the backlog of cases. Now, they deal with a certain category of offences, which includes the crimes against women and children, among others. Next is family courts. Now, the Family Courts Act of 1984 provides for the establishment of the family courts by the state governments in consultation with the high courts to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs. These courts specifically deal with matrimonial matters, child custody matters, and other family matters. So, as the name suggests, family courts, these courts specifically deal with the family matters. Next is the CBI courts. Now, the CBI courts are established under the Delhi Special Police Establishment Act 1946. They typically involve the cases pertaining to corruption and other serious offences which involve many evidences. Next, we have consumer commissions. These commissions are established under the Consumer Protection Act 2019 and they deal with the consumer dispute, the conflicts, and grievances. Now, when we are talking about the factors why we need ADR, the fourth amongst them is the judges and population ratio. So, in 2020, the number of judges per 1 lakh population in India was over 1.4. So, as you can see, the ratio is already so minuscule. The judges and population ratio, it doesn't even match at all. So the judges population ratio itself says that to the number of judges we have, to the amount of population we have, the total number of judges we have is totally incompatible. We need more population of judges. Next is vacancies. So, according to the data that is from the Department of Justice, out of 1,114 sanctioned posts in various high courts, there are currently 331 vacancies. As of 1st April, this is the data as of 1st April 2021. And this is just the data for the high courts. A similar situation exists in the lower courts itself. So, as against, you see the sanctioned post. The sanctioned post is that there are so many vacancies, 1,114. And as against that, still 331 posts are vacant. Next is limited judicial resource and procedural delay. So, when we talk about judicial resource and procedural delay, we have already seen that the number of judges are insufficient and the support staff relative to the caseload contribute to the problem. Now, already we've seen the judge population ratio and the vacancies that is pertaining. So, an insufficient number of the judges and support staff that contribute to the problem of having limited judicial resource and amounting to delay. Next is complex legal procedure and frequent adjournments add to the delay. Now, the legal process, as we have gone through earlier, it is very long, very tedious, and there can be instances of adjournments where the case is transferred to another date. So, again, it leads to delay. Inadequate case management practices. Now, how is the case managed? That depends very much on the advocate, because the advocates are the people who take your case, who present them to the court. You are not someone who, as a person in general, you are not specialized with the knowledge of law. So you need advocates to help you with that, and the case management practices, that is largely inadequate. The right to appeal and seek revisions can unevenly drag the proceedings. So, as I told you earlier, if there is any interim order passed or something like that happens, then again the case is dragged furthermore ahead. So, the right to appeal and seek revision further drags the matter more. Now when we talk about uncertainty, so the outcome of the trial, that is the trial which happens in the court, is very difficult to predict. It can be, you never know which party will be winning the case and which one would be losing. The cost of litigation is high. You need to pay the court fees, you need to pay the advocate fees. There are a lot of costs involved. So the cost of litigation is already high, and there is an uncertainty about whether the law will remain the same in the future as well. Apart from the high legal representation, we have an uncertainty that even in the future the law can change. It is very dynamic. So the uncertainty whether the law will remain the same in future or not, that is also there. Then lack of expertise. Now, lack of knowledge of legal principles leads to miscarriage of justice. Lack of expertise requires the parties to hire advocates wherein they are required to pay huge court fees. Now, as I told you earlier, that for presenting your case before the court, you need to hire an advocate. Now, this advocate knows the procedure that has to be followed in court, and since you are a layman to him, he can even misguide you. So the lack of knowledge, there is a possibility that he can misguide you. So the lack of knowledge of the legal principles also lead to the miscarriage of justice. And plus you'll be hiring an advocate, so he'll be charging a fees from you, he or she. So the payment of huge court fees also comes with the engagement of an advocate. Now, litigation creates a win-lose scenario, where one party wins and the other party loses. The judicial system, it focuses on the dispute and not the conflict. What is the difference between the two? We'll be seeing in the next class. Next is the judicial system focuses on the rights of the parties rather than the needs and interests of the parties. So as opposed to the alternate dispute resolution mechanisms, which focuses on the needs and interests of the parties also, the judicial system is focused mainly on the rights of the parties. In the judicial system, the judge cannot help the parties to get the right result. He relies on both the sides equally represented. So he cannot help both the parties by doing right to both of them. He has to focus on both the sides, he has to be unbiased, but ultimately the conclusion is that one party wins while the other loses. ADR represents a fundamentally different approach to conflict than a traditional justice system model, and is also consistent with kind of paradigm shift. So ADR has a totally different approach where we focus on a win-win scenario. So in the classes ahead, you will see how, even we'll be furnishing some examples as to how ADR is helpful in resolving those complaints or conflicts. The crafting of win-win solutions within an ADR context can be likened to an art form wherein parties are guided towards authoring their own outcomes. So in ADR, there is not the judge is not in control of the decision-making process. Let me take an example of mediation. In mediation, we have a mediator. The mediator, he controls the process of mediation, but when it comes to the decision-making process, the parties take the charge of the decision-making. It is the parties who take a decision for themselves. The consequence is an empowering one, elevating parties to conflict to a level that allows them to take a degree of authorship over the conflict itself. So in ADR, the parties themselves can take a degree of authorship over the conflict because it is them who determine the results. That is all for today. Thank you and hope to see you soon. I hope you enjoyed the class. Thank you.